Hello, and welcome to In Focus with R. Hill Enterprises, Inc., Mr. Robb Hill himself. I am your host, the best podcast host in the universe, Steve Cully. I'd like to thank our sponsors at Procyon Partners, one of the top 50 fastest growing companies in the nation. They specialize in employee benefits, wealth management, and retirement planning. President Sean Rabinowitz is a proud supporter of our podcast network, and we love him very much. Green Street Trust International is owned and operated by Rennell Jump in Yukon men's legendary basketball player Jake Voskuhl, I can finally say. They specialize in tax plans for businesses large and small. They will save you money or get you a big fat return. They also provide other financial services. To schedule your free strategic tax planning session today, go to www.greenstreettrust.com. Pete Finch and the Finch Law Firm is located in Bridgeport, Connecticut. If you suffered any type of personal injury, a slip and fall, a car accident, your mother-in-law ran you over with her car, your wife got angry one night and decided to stab you, the Finch firm is for you. Pete has won legal battles all over the state of Connecticut, and he will go to war to make sure you get every dollar you deserve in compensation. You just have to remember, in a pinch, call Finch or go to his website, thefinchfirm.com. Dynamic Human Performance is owned and operated by Yukon legendary running back Andre Dixon. Andre trains boys and girls of all ages, of all sports. He has a boot camp program 7 days a week, 6 a.m. You want to get in shape, you go to Andre. Andre has an athletic development program where he takes boys and girls in the sport of their choice, trains them from the ground up, develops them, helps them to reach their full potential, be the best they can possibly be. And hold on one second. Hello? Oh, thank you. I appreciate it. But sorry about that. And Andre has also sent kids to college on scholarship for all different types of sports. To work with the best, he has a 5,000 square foot state-of-the-art facility in Hartford, Connecticut. Go to www.dynamichumanperformance.com. Down south, we have Julius Williams and the Trench Mob. Julius trains offensive and defensive linemen in Decatur, Georgia. They go across the country and they compete in 5v5 tournaments. And proud to say they were undefeated this past season, which is amazing. And they also go to college showcase camps. And they visit, and at every camp attended, a member of the Trench Mob was offered a college scholarship. So at every camp they went to, someone from the Trench Mob was offered a full scholarship to play college football, which is an amazing accomplishment. To work with the best, and Julius is the best, go to www.battleofthetrenches.com. And Julius has sent kids to schools like Florida, Florida State, Miami, Tennessee, Clemson, Georgia, Alabama, just to name a few. So you know you're getting the best. And then we have James Whitfield of Luther James Insurance. For the last 3 years, James has dedicated himself to the art of financial planning. He also does insurance policies, and he will find the right one for you to make you money tax-free. James also focuses on retirement planning as well, because he knows the stress that goes into retirement. How much am I going to need? For how long? Do I have enough? Because fear of the unknown is real. To schedule a free consultation with James, go to www.lutherjamesinsurance.com. And now for the man of the hour, the man with the power, too sweet to be sour, Mr. Robb Hill of R. Hill Enterprises. He has a wealth of knowledge to share with us, and we're going to talk about wills and trusts. And he has a presentation to show, because his main objective, like we talked about, we as a human race, especially Americans, we got to get our heads out from that sand, because
Yes.
if our heads are in the sand, something else is raised up, and we don't want that. We got to get our heads out of the sand, and Robb and I are going to work together, and mainly Robb, but I'm going to do my best to assist him in trying to educate our Americans. So, Robb, I will turn it over to you. We have a great presentation on hand to show people. We've had some questions about wills and trusts and living trusts and that sort of thing. And I remember the first thing you said last week on In Focus was, get yourself a will. That was number one. Get yourself a will. So go a little bit more into that, and we can start with your presentation after when you're ready to go.
Okay, well, before we get started here, I want everyone listening. Hey, look.
Oh, yes. This is very important.
Get you a pen and paper, because a short pencil is better than a long memory. All right. And so the questions that you write down, these are the questions that you are going to take to your estate attorney and get everything all squared away. All right. So I'm going to go into this. I'm going to move pretty fast, but it's a lot of information. Okay. So let me present
it's a lot of information, guys. And remember, the podcast is going to be posted. It's on YouTube, Facebook. It's going to be on Instagram. So you can go back and watch certain portions of it, but try to take down as much as you can now while it's fresh in your mind, and then go back if you need to refresh on anything, because this is valuable information that people pay money for to get. That you're getting a crash course here for free. Okay. And if you have any problems loading it, just let me know, and I can definitely do it.
I'm sharing my screen now.
Okay, beautiful.
Share.
Yep, there it is on the bottom.
All right.
And then all you have to do, or actually, I think I can add it. And there it is. I added it, and then I'll make it big.
You got it now?
Yeah, there we go.
Okay.
Yep, I got it big. It says wills and trusts.
All right. And so we're going to blow through this thing, all right? Everybody got their pen and their paper.
Pay attention to this, yes.
Here we go. Only 3% of family assets on average survive to the fourth generation. Why is that? Okay. It's due mainly to ignorance on a lot of people's parts. All right.
Well, because you had been saying that if you don't have a will and trust, and if you don't have a next of kin, you were saying the government gets those assets.
You got the cart in front of the horse, brother.
Oh, sorry.
We're coming to that. We're coming to that. All right.
Yes, sir.
Okay. So how a trust could benefit your estate plan? Eliminate estate taxes on your life insurance death benefit. Okay. A lot of people really understand that life insurance is not taxable. However, in some cases, it has to be reported to your estate, or it has to be claimed in your estate. And that opens up the door for taxes. All right. So you preserve your estate for future generations, not the next generation. We're talking future generations here, ladies and gentlemen. Okay. Protect your estate from future creditors or divorce. All right.
That was actually one of the first questions that just came up. Mm-hmm. Can your estate be sued?
Yes, it can. Most definitely.
It can. Oh, okay.
Oh, yes.
Wow.
Oh, yes.
Okay. I didn't know that.
This is why you would put it into a trust.
A trust. Okay. Wow.
What is a will? A will is a formal and legally enforceable statement of how you wish to dispose of your property upon death. That's it right there, cut and dry. That's what a will is. A valid will allows your last wishes to be protected by law. It can be changed at any time prior to death, and it can be used to express kindness, anger, surprise, and appreciation. Okay? Yes.
I don't want to disrupt your presentation.
Okay.
Question.
What's going
So
on?
just keep going.
Why is a will important? Without a will, you cannot control who will inherit your property upon your death. Should you die without a will, your property will be distributed according to the laws of your state. And we got a lot of very liberal states out there, and you definitely got to protect yourself from that. All right. So why should I make a will? Or no, who should make a will? Every adult should have a will. You need 2 qualifications to prepare a will. You must be 18 years old and you must be of sound mind. A sound mind it means that you must understand what you are giving away and to whom you are giving it.
Right.
You must prepare your will free from implied or actual threats, pressures, or trickery. The will should be written in the state of residence. Okay. So dying without a valid will, you die intestate. When someone dies without a will, that person is said to be intestate. The laws that govern the distribution of property in such an estate are known as the laws of intestate succession. These laws determine who your beneficiaries, your administrator, and the guardian of your children will be. Okay? So you got to get a will in order to prevent some bureaucrat from deciding what happens to all your stuff. Okay?
That's scary.
Definition: heir versus beneficiary. An heir is defined as a person legally due to inherit with or without a will. A beneficiary inherits through a will or other document, such as an insurance policy. Next of kin refers exclusively to those who are blood related, while heirs usually refers to anyone who is entitled to inherit property from the deceased under state law. Example: Bruce and Helen had a sizable joint-held estate, a home in California, and no children together. Neither had a will. Bruce died first, and Helen died a few days later. The California laws to intestacy distributed all jointly held property to Helen's brother. Bruce's 3 children by a previous marriage received none of Bruce's jointly held assets. That should be alarming. That's a wake-up call, ladies and gentlemen.
Right, okay. Because he died first. Everything he had goes to her.
Right.
And then everything she has goes to her family.
Right. Because
I've heard about that.
Okay.
Oh, my God. Wow.
Yeah.
But that can be contested, though, correct?
Well, everything except when we get into the trust and all that. See, trust, that's a whole another animal, all right?
Gotcha.
But yes, your will can be contested. Okay. But if you've done it right and all that, there won't be
there's no
reason to come to it, right? So there are 3 types of property to include in your will. Okay, we got real property, which is real estate property and buildings. We got tangible property, which is property you can touch and use in its physical form, and then we've got the intangible property that may be represented by paper such as stocks, bonds, copyrights, and patents. And there's an endless list of this, okay, of these things. All right. So, definition: escheat. When there is no will and there is no surviving spouse or heirs, estate property is said to escheat or pass to the state. You got that? You gotta have your stuff going somewhere.
It goes.
Else it's going to go to the state. And our government has an insatiable appetite for other people's stuff. Okay?
So, can I just ask people who end up in nursing homes,
Mhm.
and if they have no living relatives or anything, they
Mhm.
die in the nursing home. You're
Mhm.
saying that anything left in their estate goes to the government.
Yes. And this is what this right here is the disclaimer there. The state tries to find heirs for 10 years. Then the estates revert to the state permanently. So you should notice it say they try.
They try. As I said,
You know,
they
that,
try.
that that's that weasel clause,
That's
right?
very subjective.
Yes, it is.
Yeah.
Yes, it is. Okay. So we know they're not trying.
Yeah, they're not sending out investigators.
No, they're not. Okay. So the joint will is the single will of two or more testators, such as a husband and a wife. Okay. People may separate, lose the copy of their will, or destroy the will without the other's consent or knowledge. Hence,
Oh,
prepare a separate will for each testator, even if the wills are identical.
wow.
Okay. Yes, yes,
That's scary.
yes. But see, it's only scary when you don't know.
That's what I'm saying. You wouldn't know. I mean, if it's a divorce, you wouldn't know.
All right. So videotaped or audio tape wills,
That's what I would do.
no state recognizes these wills as valid.
Well, okay.
So
Thank
don't
you.
even
No.
consider that. Don't even consider it. Okay. Videotaping is one method of establishing the identity and alertness of the testator, but it's not going to do you any good when you try to do your will that way. Accompany it with a formal will. So you can have both of them together. But a video by itself is not going to do it.
Nothing. Oh my
Okay.
God. I never knew that. Wow.
All right. The elements of a valid will. The will must be in writing. You hear that? The will must be in writing. The will must be signed by the testator. That's the person whose will it is. The will must attest to 2 or 3 adult witnesses who will not benefit from your will. And use your legal name on your birth certificate. Okay? You hear that? So if you're a woman and you marry a man, okay? Well, you're gonna marry a man anyway. I don't know why I said that, but you get married, you got to use your maiden name on your will. Okay, all right, and then you can make a statement in there that you assume the name of your spouse. All right,
So can I ask a personal question?
sure.
So my parents, are you saying that my parents may have separate wills?
Yes, they can be identical, but the reason why there needs to be two wills is like they said, in case of
Whoever goes first or
right,
whatever.
where someone may go or they may divorce or anything like that. I mean, lots of things happen.
Okay.
Okay,
Okay.
and that's why they can be identical, but each person needs to have one.
Right. Okay.
Okay, so a self-proving will. Although use of this clause is not a strict legal necessity, it is strongly recommended that you prepare and use this clause with all wills. Although few states have not enacted legislation to allow for their use in court, the current trend is for all courts to allow their use. This clause will allow for your signature on your will to be proved without the necessity of having the two witnesses appear in court, a point which will save time, money, and trouble in having your will admitted to probate when necessary. Okay? Your personal representative. This is very important right here. An executor. That is the person the testator chooses to handle their affairs of their estate, handle the affairs of their estate. An administrator. A person appointed by the probate court to assume the duties of an executor should a person die without a will. All right? One moment. Pardon me for that interruption. Okay. So everybody got that, right?
Yes.
Okay.
Yes. So I mean, you're getting we're getting a lot of questions.
Okay.
Um,
Let's
yeah.
go
Yeah.
through this.
We'll keep
We'll
going.
have a Q&A at the end.
Yeah.
Okay. After your will is completed, do not make any changes directly on the will after it has been completed, signed, and witnessed, because those changes will not be valid. Prepare a codicil or prepare a new will if you want to make changes. Okay. Then, if you create a new will, destroy the old will.
Oh.
Okay. What is probate? Now, this is what we want to avoid. Okay. Probate court is the entity that processes the estate of a deceased person. With a will in place, you can avoid this totally. All right. The probate estate is all of a person's assets that go through the probate process. Last will and estate planning. Without a will, you cannot ensure that the property you leave behind goes to the people you want it to.
Very true.
Without careful planning, your heirs may encounter some serious tax and property ownership issues. Okay. Definition. Homestead is the primary residence, exempt from creditors' claims. You hear that? Exempt from creditors'
Exempt.
claims.
Yes. Okay.
They may include houses, mobile homes, houseboats, vacation homes, all that kind of good stuff. All right. Durable power of attorney. Avoids guardianship if you lose capacity. Okay. Right. Meaning that, say you were in a car accident and your faculties are not 100% anymore. Okay. This is why you need a durable power of attorney, because we never know what's going to happen. And if you do lose capacity, you cannot pick your power of attorney then. So you need to do this prior to anything happening. Okay. Someone steps in to manage the finances for your estate. This is what a power of attorney will allow a person to do. Correct. On your behalf. So you got to make sure they're trustworthy.
Correct. Because they can run wild if they want.
Most definitely. Pre-need guardianship is if you are a danger to others, meaning that you're homicidal. Okay. I'm going to rip their head off when they get here, things like that. You say things like that frivolously, and they can have a dramatic impact on with as far as the law is concerned. Okay.
Wow.
Pre-need guardianship may be necessary due to third-party interference. Third-party interference is someone contesting whether or not you did what you needed to do as far as the will is concerned. Okay. Now, minors, ways to appoint guardians. Pre-need guardianship, power of attorney, petition the court, and both parents must sign and say if something happens to both parents, who's going to take care of the kids? Okay. This is what that is addressing right here. Okay.
So naming a godfather or a godmother, that's legally not binding?
No, if you put it in the will and the documentation, yes,
it has to be documented. Okay.
Yes, it does.
Okay. Just verbally saying it, it's nothing.
Okay. So now you got a living will. What is a living will? This type of will takes effect before you die and may include the right to die, meaning that you don't want to be in a vegetative state or in a coma or whatever, and all that. Number 2, to die with dignity. And we keep moving here. The types of medical treatment, CPR,
right? The DNR.
And this is when they're trying to keep you alive or whatever.
The DNR, okay? Yeah.
Artificial feeding
tubes. Yeah.
No autopsy. And
really?
When my grandmother passed, it fell upon us to decide. Well, when she was in the hospital, she was real sick, and they had her plugged into these life preserving
Yeah,
machines and
yeah,
all this kind of stuff. And
yeah.
they looked at me and they said, "So what should we do?" I said, "Release her, let her go."
Wasn't even a
Yeah,
you knew what
yeah,
she
no,
wanted,
man.
and you were
Yeah,
like, let her
let
go,
her
let her
go.
go.
Release her. We're holding her prisoner. Let her
You
go.
really are. Yeah.
Yes, let her go. You know, I mean, and not only that, but it ain't free. the, the
No.
hospital is running up them charges like you
They
won't believe.
do. They do
Okay,
every minute.
and so that's why in my will, hey, look, don't revive me.
You have a
Okay?
DNR?
Oh, I have a will.
No, but I mean, you have like a DNR saying like,
Yes, do
if
not
you were to
resuscitate.
go,
Yes, yes,
wow,
let me go.
let
Release
me
me.
go,
Yes,
release me.
yes. Okay, overriding a living will. Your family cannot override your living will.
I know that. I know they try.
Yeah. Now, trust. Now, this is very important because you don't necessarily have a will or a trust. You have them both.
Both.
Yes.
Yes. That is important,
Okay.
everyone. You have to have
So we're
both.
going to go over a brief little history here. Trusts have been around since the Roman Empire, about 800 AD. Later, English knights used trusts to protect their lands when they went into battle.
Oh my God.
American trusts have been used since the 1700s, helping colonists protect property from English taxes and government.
Wow.
Why create a living trust? To avoid the difficulties of probate. You hear that? The key word there is avoid.
Avoid.
Enables you to transfer your property seamlessly without some bureaucrat behind the desk telling you what to do. Okay. And you can transfer your property directly to your trust during your life without court involvement. After your death, the person that you appoint to handle the trust may then simply transfer ownership to the beneficiaries you named in the trust. Okay? And we continue on here. Definitions of a living trust. Definition of a living trust. A legal agreement in which a person owning property, the grantor, hands over legal title to his or her property to a second person, the trustee, who manages it while the grantor is alive. Notice
Oh.
that word alive right there means that they could very well be incapacitated.
So can I ask? I'll ask the
Yes.
question. I have a 97-year-old grandmother.
Mhm.
My mother and her sisters are up there daily, kind of taking care of her. So could they have something like this, a living trust, where they
Yes.
make decisions in her best interest because she's
Well,
in the
yes,
little one cuckoo's, over one flew over the cuckoo's nest sometimes.
right. Well, see, but she has got to be
She's
cognizant.
got she's got dementia. She's got
Yes.
dementia.
Well, see, when you get to this point, it's too late. All right, because
Well, right.
she's not
She
she's
can't
not
make that
cognizant.
decision,
Yes, she can't make the decision. So
so it had to
we,
have been done
you gotta
before.
you gotta do these things before
Okay.
something happens. Okay. Okay, we're gonna continue on now.
Yes, sir.
Living trust continued. As grantor, you do not give up the right to use or sell the property. It is simply put in another entity's name to avoid probate when you die.
Right.
Living trust continued. A simple, inexpensive legal alternative and may eliminate costly estate probate charges, attorney fees, and delays of probate. Okay?
Yeah.
So this you can totally bypass all that bureaucracy
And it
by
drags
simply
on if
putting
you
this in
don't.
place. All right. So a living trust ensures that your loved ones receive their inheritance when they need it most right now. Okay?
Very true.
Okay, continue. You have the final say as to what happens to your all trust property. With a living trust, there is no waiting, no public record, meaning nobody can contest it, and significantly reduces attorney fees at the time of death. Significantly reduces. I mean, knocks them way down. Living trust continued. A living trust can be canceled or amended at any time prior to the grantor's death or legal incapacity. If you get incapacitated when you got this thing in place, it cannot be changed.
Right, because you're not of sound mind.
Right?
It is what it is.
Right. So
That's
it can be used alone or with a will, but I would caution everyone, you need to have both.
Both.
Okay.
Well, I'm saying absolutely you need to have both.
So you don't have to have a large estate to establish a living trust. Okay, so don't well, I ain't got nothing to leave nobody. Trust me, you need to do this. Okay?
Yeah.
You need to do this. Because, as quiet as it's kept, when there's a death in the family and there are other family members, man, the devil comes out. The devil's in the details, brother.
Oh, it does.
Oh, yes.
I have seen it, and there's some questions about it. And yes, I've seen wars go on over it.
with a properly created will, all of that can be eliminated.
Yeah.
Okay, so we're continuing with the living trust. It shortens the time to distribute funds by months or even years because probate takes time. They're on their own time frame.
They sure are.
So difficult to contest or overturn your wishes regarding your estate. All right. So somebody may try to contest it and all that, but if you got all your ducks in a row, there's nothing they can do. Okay. Even if in the event that, say, you had two siblings battling over it, right?
Correct.
And one of the siblings is simply a spendthrift and has no idea how to manage anything. The other one is very responsible. Correct. And so they put everything in the responsible one's hands, but this spendthrift over here is upset and he wants to fight it. He wants to battle it, but he can't do nothing about it. Okay? Now, if there was no will, there would be a drawn out battle going on between those.
There would be a war. Yeah.
Okay. And so it remains completely private. That's what a living trust does. It remains completely private. Now, we continue on. Points to remember. And this is where you write down some stuff in addition to those other questions that you have. A trust is hard to challenge in court. One of the worst risks associated with filing a will is that someone may legally challenge its validity in court. That's what you addressed when we first started.
Yes, I did. Yeah.
That was the question right there, and there's the answer.
Yes.
Okay. So we'll continue on with points to remember. Privacy is assured. You control your assets. Provides conservatorship rights. Out-of-state property is protected, and trusts are legally recognized across all states. Okay? Important facts. Your income taxes are unaffected by a living trust.
Wow.
Upon your death, your heirs will save on federal estate taxes. All right?
So the estate will not be federally taxed.
Right. That's why you got it in the trust. Remember, we had that conversation I was telling you about staving off taxes?
Yeah.
Okay? Yep. There are many different types of trusts, ladies and gentlemen.
You did say that.
Okay, many different types. So when you go in there, you make sure you have all your questions down and say, well, I want to put this in a trust. A trust is a legal entity. Okay. And your benefactors to that trust, they have use of everything in that trust, but they don't have to pay any taxes on it or anything like that. It's a
Right.
beautiful thing. Okay. You know what? And I'm just going to put this caveat in here. We live by the golden rule. And if you don't know what the golden rule is, it is simply this: he who has the gold makes the rules. Okay. Right. So
That
we
is the
continue
truth.
on here. So definition: revocable. That means that you may amend or cancel the trust agreement or appoint a new trustee at any time. Okay. This term also appears in life insurance policies, where you have a revocable beneficiary and an irrevocable beneficiary, which we're going to go into. The revocable means you can change it. Okay. Then you got the revocable living trust, meaning you can change it. A trust that takes effect while you're alive, and it can be amended at any time. Okay. The AB trust, this is for married couples. An AB trust is a type of revocable trust, revocable meaning that it can be changed, for married couples, whereby the couples are able to do some basic estate planning. Irrevocable living trust is exempt from federal estate taxes because the trust is not considered to be a part of the grantor's taxable estate. That is beautiful. That is beautiful. Okay?
Yes.
It keeps them other hands out of your pocket. Okay.
Yeah, they try to get into everything. Jeez.
Oh, they don't try. They do.
They do. I'm sorry. They do get into
Real
everything.
good. There is no try. Okay.
No,
They do what
they're
they
into
do.
everything.
Yes, they do what they do.
That's amazing to me.
Okay. Goal. Here you go. Write this down. Keep all you can. See, it's not what you make that counts, it's what you keep.
Keep.
Okay.
And you're working all your life for this.
Yes.
This
See,
is your life's work.
Right. It is your right by law to take out of your name as much money as possible, keeping it from the IRS and other agencies so your beneficiaries will inherit instead. You know what IRS stands for? A lot of people think it stands for the Internal Revenue Service. I got a new one for you. It is the Income Reduction Squad. Okay.
Oh, that's great.
All right.
That is so true.
Yes, it is. The IRS, you know what? The IRS, they could be named a terrorist organization, because when you hear IRS, man, the hairs on the back of your neck stand up.
It does. It
You
does.
got a letter from the IRS, man. That's like saying Al Qaeda's coming.
No, it is. It is. Hamas is coming to get us all. Oh my God.
Yes. Okay, so we're gonna get rid of that.
Wow.
Okay. All right. We're continuing on here.
That's scary.
Caution. You are giving up the right to control and amend your trust. There may be gift tax consequences resulting from transfers into an irrevocable trust. It says there may be. Okay. Remember, don't give the probate court control of your assets.
No. That's
Okay.
the last person you want. The last group you want.
Right. An insurance trust. Okay. Putting a life insurance policy into an irrevocable trust allows the death benefit to be excluded from your estate for estate tax purposes. That is beautiful. Okay. That is beautiful right there. So write that down, ladies and gentlemen. Insurance trust. Okay. When you speak to your attorney, make sure you bring that up. Okay. Now, an insurance trust. Trust is irrevocable, meaning it cannot be changed, and you can't get money back when you need it. Okay, so this is what you don't do if you purchase an IUL. That's an Index Universal Life Policy.
Yeah,
you don't put that into you don't put that into a insurance trust. Okay,
right.
You let that stand on its own. All right,
right.
Because like one of your previous guests was saying, you use it as a
James
bank
was
account.
talking about it. Yeah,
you want to use it as a bank account, then you don't put it in a trust, because if you put it in a trust, you're not going to be able to use it.
You're not going to get it. Yeah.
Okay, but it will build.
It's very specific. I see what you're saying.
Yes, it will build, and you can leave it to your heirs. Okay. The scripture says in the book of Proverbs, it says, a good man leaves an inheritance to his children's children. Okay.
Right, right. The generational wealth, like you
Right.
mentioned.
Okay. So we could continue on here. The grantor must pay premiums on the life insurance policy. Without paying the premium, the insurance policy is not going to last. All right. So we can continue to move on here. An insurance trust without the use of an insurance trust, an individual must include the face value of any life insurance policies in their estate. Okay. This is how an insurance benefit can be taxed, because it has to be included in your estate.
Right.
Okay. So we want to avoid all that. So this may force payment of estate taxes. And it says may force. Okay. It doesn't say will force. It says may force. So there are ways around these. All these different things, there are loopholes in them. And when you sit down with a good estate attorney,
Right.
he's going to point all this stuff out to you. But see, if you don't ask the right questions, you are not going to
get the right answers.
Okay.
Can you give us an idea of what percentage would be forced on an estate tax? Is there a percentage, or is it based on the amount that's in the estate?
That's another presentation that I have.
Oh, okay. We'll hold off on that. I'm sorry.
Talks about that. That's another presentation. Okay. It's my presentation to consumers.
Okay? Right. I got
you. In that presentation, I go into that. Okay.
Gotcha.
All right. So that's for another time.
Yes, sir.
We're going to continue on here. Testamentary trust. A trust created through your will. You hear that? A trust created through your will. And it must go through probate. Community property. A husband and wife commingle their property, meaning that what's yours is mine and what's mine is yours. Okay? And that's not how it usually goes, though. The wife says, what's yours is mine and what's mine is
mine. Mine is mine, yeah. Ain't that the truth?
I digress. Let's keep going here. Okay, spendthrift provision. Remember I brought this up?
You did, yes.
Okay. A revocable trust may contain spendthrift provisions that prevent beneficiaries from assigning their interest in advance, meaning they want to go and buy a Ferrari, you know?
Yes, with the Menendez brothers. Yes.
Yeah, that stops all of that cold.
They were buying Ferraris. Yeah.
Additional elements of a trust. The pour over will, a very interesting term. It's a supplement to the trust, and it catches any assets not in the trust. All right, y'all got that?
Yes.
Okay. The Unified Tax Credit Exemption, Economic Recovery Act of 1981, single versus couple. Remember this. The Economic Recovery Act of 1981 allows a federal exemption called the Unified Tax Credit Exemption.
Yeah.
The gift tax and estate tax share similar concepts. A single applicable exclusion amount permits anyone to give away up to $2 million in 2008 in assets during their lifetime as gifts or at death under your living trust. Okay, these laws are going to be changing because we got the illustrious Donald Trump in there now, and
we do.
Yes. Okay,
so
but, I mean, you know what? There is nothing you can do that doesn't have a government fee, a tax, or permission.
It just seems like they're involved in,
every aspect of our lives, man. Our government is way too big.
They just take wherever they can.
Do you know that you roll out
of my soda if they want?
Yeah. You know that you roll out of government approved sheets?
No, I did not know that.
You look on your pillow. You see that tag on that pillow? The tag on the mattress? All that? That's all government approval, man. But that's another
that's another story.
Another presentation, okay? Okay, so paying estate taxes. Many estates do not pay federal estate taxes because there is a $2 million exemption and an unlimited marital deduction.
Right.
You need to know that.
Right. I get that, but
Okay, your estate may still be liable for paying federal and state income, gift, and state inheritance taxes. All right, it says you may still be liable. That right there lets you know there's a way around it. Okay.
yes. Yes.
Right.
This is
Oh wait. Remember, all taxes must be paid from your estate before any bequests are distributed. Like,
right.
listen, you leave a $300,000 house to your daughter. Guess what? She got to pay taxes on that thing before she receives it.
Before she can even do anything with it.
Unless you put it in a trust. Okay.
So that's why you said it's important to have a trust and a will.
Yes.
You have to have both.
Remember, you must decide who the trustee and secondary trustee will be. The name right there says it all, trustee.
Okay? Exactly.
There are ways to control this from the grave. You hear me? Remember, no matter who serves as your trustee, it is advisable to have at least one successor trustee. Okay? Meaning that right. When James goes, then Julia takes over. Okay? This is just an example. Choosing your trustee. This is very critical right here. Self, spouse, relative, attorney, close friend, or your financial advisor. Okay? So those are just some suggestions right there. Okay? So choosing your trustee again. Even if you are your own trustee, your assets are protected from probate. Let me repeat that. Even if you are your own trustee, your assets are protected from probate, since legally they are owned by the trust, a separate entity rather than you. That is key. Write that down, ladies and gentlemen. I'll give you a moment to write that down. Even if you are your own trustee, your assets are protected from probate, since legally they are owned by the trust, a separate entity rather than you. All right? That's very good information right there. To prepare, this is an example. Your real estate deeds, corporate stock certificates, bonds, all bank accounts, all your assets, your cars, all them tangible things, your accounts receivable, all this stuff. You need to get all this stuff and include this in your trust.
Right.
Okay, to prepare, again, we're continuing. Proof of property ownership, antique or classic cars, and I broached this already, but total all your assets and debts, including mortgages, bank loans, and other expenses. Not included. Personal autos, insurance not payable to the estate, S corporation stock. And in general, S corporations do not pay any federal income taxes. Instead, the corporation's income or losses are divided among and passed through its shareholders. The shareholders must then report the income or loss on their own individual income tax returns. This concept is called single taxation. If the corporation is taxed as a C corporation, it will face double taxation, meaning both the corporation's profits and the shareholders' dividends will be taxed. That is critical right there.
That's very critical.
Yeah. Just a second. I gotta take this call.
Go ahead, sir.
Yes, Dave. Hey, can I call you right back, brother? Yeah. Okay. All right. Yes. So everybody get clear on that, because, well, most people don't have any corporations or anything like that, but you may have stock. Okay. So this is something that you really need to include in your trust. Okay. Everybody got that?
Yes. Yeah. Yes.
Remember, with a trust in place, your family does not have to go to court, appoint and pay a personal representative to administer your estate, prove the validity of your intentions, no long delays in distributing the estate, limitation of transferability, meaning that it ain't going to get transferred to somebody that wasn't meant to be transferred to. Okay. This information the information you obtain at this lecture is not, nor is it intended to be legal advice. You should consult an attorney for individual advice regarding your own situation, because we all have different goals and plans and things like that.
Yeah, so, different families. Yeah,
right. But you definitely need to get with an estate attorney.
Correct.
Okay? And there are a lot of questions that can arise from this presentation, and it's going to be recorded so you can go over it again and again and again and write down these questions, and you take these questions to your attorney, okay? And you get him to answer these to your satisfaction, all right?
Right. Okay. Absolutely.
Okay. There we go. Any questions? I can take a few questions right now.
Okay, so somebody wanted to know about if you're familiar with Ted Williams and the battle over his estate when he allegedly was somewhat incapacitated. They had him write on a new will on a napkin, basically saying that he wanted to be part of cryogenics and be frozen. You know what cryogenics is?
Yes, I do.
Okay. So John Henry, his son, went to court, and apparently they won, saying that the will that he wrote on this napkin, saying that he wanted to be cryogenically frozen, was legally binding, and he was able to do so. And they were just curious. When you do a will or a living trust, is it something that needs to be notarized?
Yes.
Okay.
See that thing about him doing his will on a napkin and all that?
Do you remember that at all? When that happened?
I haven't heard of that, but that is very suspect.
Yeah. They people thought it was suspect because he was incapacitated.
Yeah, that flies in the face of fiction.
So many different things.
That's fiction right there.
That's Massachusetts, so that kind of makes sense.
Yeah.
So this makes sense sort of to me. So my grandfather, when he was 77 years old, my father's an attorney, and they started transferring, like, for my birthday present. My grandfather gave me a check for when I was like 10 or 11 years old for $15,000.
Right.
He gave my brother a check for like $15,000. And this just had me thinking maybe it was transferring money as gifts to prevent taxes on them. Would that be something?
That could definitely very well be the case.
That could be the case.
Oh, yes, definitely. See, that's
what has me thinking.
That's what you call smart.
So my dad's smart.
Right, because the government they'll put their hands in your pocket and won't take it out.
Yeah, no, that's what you said. That's what you said.
Our government has what I like to deem an insatiable appetite for other people's money, because our government in and of itself does not produce anything.
No, they just take.
No,
they just take. That's how they survive.
Yeah.
The other question several people asked, I don't know if you're familiar with the Anna Nicole Smith, the probate case that she went through.
Right.
She went through the probate case with, she married the billionaire Texas oil guy who was 4 years older than her. He dies, and, she was promised the estate. Her son was promised the estate. They went to probate court they had war for like 3 years, and she ended up getting part of it, but the majority of it went to the son because they felt that Anna Nicole was basically inducing John Henry, the husband, to sign over his will and assets to her, in not the best manner, and they went to probate court, and the court sided with his son over
Right.
it
Right.
because of that. And that was a case where the will was contested because
Hmm.
they were saying he was incapacitated
Well,
at
there
the
was
time.
like I said, you remember from at the beginning of this presentation, I said, look, you
Yes,
cannot be coerced or forced
yes,
or
yes,
threatened or anything like that, you know.
yes. He was definitely coerced. So
Okay.
she was given some of the money. He was given the majority of the money, and it was
Yes.
crazy because they both ended up dying within 3
Hmm.
years. The other question several people asked: so if there's a will and an executor of a will can and the will has certain assets, stocks, bonds, whatever, can people still use that their assets, the executor of the will, to continue to make money off that person's assets before
Well, see, that's
distributing?
that's that's where the will and the trust go hand in hand. See,
Okay,
that would have to be in the trust
okay,
in order to
okay.
keep that going like that, in order for it to be still producing.
Okay, because people were saying like Michael Jackson, for
Hmm.
example, his will or trust or whatever says that his estate can continue earning money because he receives checks, from his
Right,
albums, obviously from
right.
this and that, and they can invest in certain things and continue to grow the estate even though he's not alive anymore.
Well, see, that's what you call the legacy that he left behind.
Okay,
And
okay,
see, that legacy it lives on as long as the proper wills and trusts are in place.
right,
Okay,
right,
like I
okay.
said, now when you say will and trust, see, there are a lot of
There's
different
different.
types, different
Correct.
types
You
of it.
went over several
Right.
different types of them.
So
Yes.
this is where a person needs to figure out exactly what's going to help them meet their goals.
So when you sit down with a potential client or a client, do
Mhm.
you go over and do you make suggestions like, okay, based on what I'm hearing from you, from your assets, from your wishes, this would be the best trust for you to get
Well,
into. This would
actually,
be the best
no,
trust.
actually, I don't do it that way.
Okay.
What I say to a client is, have you considered?
Have you considered? Okay.
Have you considered?
So you're not one. You're never going to tell someone, "I think this is best for you."
No,
You'll say,
no,
"Have you considered
no.
this?
What
Have
I
you
would what
considered
I
that?"
would do is I would have them consider all the options
Okay.
and then let them choose which route they want to take.
Now the question was, basically, if they choose something that you think is a really bad decision,
Mhm.
is that something you'll delicately inform them of? Like,
Well,
maybe you should think about this, or
actually what I would do is I would simply do this. I would make sure that we're on the same page first. I say, so you want to do this, this, and this.
okay, so you lay
And
it
then
out.
okay, and I say, okay, so now we're on the same page. We're talking about crystal clear communication here. Okay.
Okay,
So I want to make sure that I understand exactly what they're saying. And
right,
then I would say, have you considered this?
right.
This,
So
this, and this. All right.
right.
It's just I'm not telling the person to do anything. Okay.
That's what I
But I
see.
am
So
giving them enough information to make an informed decision.
and that's what I see is much different from the way that you operate, that I've seen other people operate,
Right.
where they say, okay, this is what you need to be into.
Yep. Yep.
You
That's
don't
it.
do that.
I don't do that. No, I
You
don't do that.
say you give them the information.
Yes.
You ask them, have you considered this? You get on the same page.
We
You
got
make
to
sure they know.
before anything happens, we got to be on the same page. Have you ever been talking with somebody and say, you know what I mean? You
I
know what I mean. Well, no, see, I don't know what you mean.
I
No,
have, yeah.
no. Let's put it down A, B, C, and D. See, 2 plus 2 equals 4.
Correct.
And if you tell me 2 plus 2 is 5, we on a different page. You're on a different
Correct.
page. All right. So
Correct.
what we got to do is we have got to have this thing called crystal clear communication. George Bernard Shaw said the biggest thing about communication is people thinking that they've had it. Okay.
Well, no, you're absolutely
Yeah.
right.
So what
You're
we got to
absolutely
do,
right.
we got to get crystal clear. Okay.
Right.
Crystal clear communication. So I don't tell people what to do. No, I show them their options. I point out the options. Okay.
Right.
And then I
Right.
let them make their decision. And I tell them the good and the bad with whichever way they want to go. Okay. But they make their own decisions.
So Nocturnal here is asking if you know a client is potentially making a bad decision.
Mm-hmm.
They have all the information. You've gone over it with them,
Mm-hmm.
and because you've been doing this. You know that they're probably making a bad decision. Is it something where you would speak up and say again? Are you sure about this? Is this exactly?
Well, I wouldn't say, are you sure about this? I would say, have you considered?
So that's what you go
Have you
back
considered?
to.
Okay.
But you would still even if it's a bad decision, it's them. You're going to let them go with it. It's a free country.
Well, it's not so much that I would let them go with it. What I would do is I would point out the ramifications and the consequences.
Okay, so you would say this is why.
Say, look, this right here will do this, and this is what could potentially happen, as opposed to consider this.
Right.
And we can avoid all that. It's like having a will and not having a will.
Right.
Well, you don't have to do a will because it's going to take you a little time. You got to think about it and all this kind of stuff. You got to decide who's going to be the beneficiaries versus the heirs and all this kind of stuff. Or you could just not have one.
Yeah, right. Exactly.
And you can let the bureaucrats decide.
Yeah.
Okay. But see, what the beauty of what my mission is like I said earlier, pull the ostriches' heads out of the sand.
Yeah, and they need to be.
And we give you enough information for you to make informed decisions. See, what happens is this right here, Steve. Information listened to over and over again becomes knowledge.
Yeah.
100%. Knowledge will give you confidence.
And power, yes.
Confidence will get you to doing an activity. That activity will turn into a habit, and it is your habits that determine your long-term results.
One other question I'll give you the last question. So when a person's preparing a will / living trust, is that where they can say, I want my couch to go to my brother Jim. I want my picture to go to my cousin Lisa. Is it that specific?
Yes.
Okay, it is.
Yes. The more specific, the better.
The more specific, the better.
Yes.
So the less ambiguity.
Right. We want to take all the ambiguity out. We want it crystal clear.
And the person wants to know, can they also say, okay, I want all of my assets to go to my wife. I want everything. Is it that simple? That can they do that?
Yes, you can do that. And see, if you don't have a will, the laws in your state will essentially do that.
Well, I mean, if they want to put that in their will, like
I would strongly suggest get a will.
Yes,
and get very specific in that will.
Right,
and then look into the trust aspects. There are many different types of trust. Look into that too, because if you get incapacitated,
you're screwed. If
that will is going to take care of everything, and you know that you're going to get that power, that durable attorney, and all that kind of stuff. Get that in place before you need it, because it is better to have it and not need it than to need it and not have it.
I mean, the same person asked if you do get incapacitated, you have a living trust. Are you able to set limits on
not after Not after.
No, before. Are you
No,
before?
before you can do that, yes.
You can say
Before you get
they can only,
incapacitated, you got total control. But
you can,
once you get incapacitated,
you're done. Yeah.
it is what it is.
But before they can say, all right, I only want them to get this much allowance per
Yes.
month. Or I only want
Yes.
them to.
You can
They
do
can't
all of
sell
that.
my car. They can't do this. They can't do that.
Yes. Yes.
You can do that. Okay.
Well, so you put everything into a trust, and
Yes.
they can have use of it, but they can't sell it.
That's what I'm saying. That's what he was
Yes.
asking. Yes.
Yes.
So you can protect yourself.
Oh
that
yes,
way.
definitely,
Okay.
definitely.
Okay. All right. Well, I won't keep you there. That was a great episode. I am going to put this up. It's going to be on Spotify. It's going to be on Facebook, Instagram. It'll be on everything for people to see. This was a phenomenal episode, very educational. I learned a lot. I am going to rewatch it because now I like my father's an attorney. He does he does family law, he does criminal law, but he does a lot of probate.
Mm-hmm.
And now it makes sense to me some of the things that he's done over the years with us, with our grandparents, with the way they move money and assets around. Now it makes sense a little bit more because he was thinking obviously of the tax implications of the federal government, and that just blows my mind. That now I realize, oh, my grandfather was giving me $15,000 for my birthday as a gift. Why? I was like, well, now I get it. Now I get it. They were moving the money to start moving it to get it tax free because it was a gift. So unbelievable. Great episode. Thank you very much, Mr. Robb Hill, R. Hill Enterprises, Inc. We will list also your book on Amazon. Make sure people purchase that, and people can get in touch with you on your website. And we got a couple speaking engagements in the works. We're gonna find a way to get you out to Connecticut. It's gonna be a lot of fun. So I appreciate your time. I appreciate your presentation. That was awesome.
Okay.
So, Mr. Robb Hill, I'm Steve Cully, the best podcast host in the universe. Remember, when life gives you lemons, don't make lemonade. Take 2 oranges, throw them right back at life.